started here. So thanks for joining us today. Any questions before I jump into what I'm going to talk about? Okay. Well, I'm going to assume you guys can hear me and everything's good to go then, but we'll go from there. All right. So here's what I thought. Oh, there we go. Jeanette gave me a thumbs up. Thank you. So what I thought I would talk about today is I actually got a call this week from an agent in our company who actually has been an agent for a very long time, does a good amount of business, actually a lot of business, and was talking to me about a contract that they had that was during the due diligence, they had asked the seller to make some repairs, and now they were saying, hey, the seller is not wanting to do those repairs for some reason. And so, what are my options? And so, we talked through the options and stuff, and I just thought that'd probably be a good reminder for us to talk about today as well. So, let me share my screen here. Get to the I'm going to pull up the Repsy for a minute here and just talk for a second here about let me hide the thumbnails here. Maybe. There we go. So due diligence. So during the due diligence period, obviously, this first part is actually probably nothing new that you guys don't know. So I recognize that, but I think it's helpful to make sure that we understand this first part so that as we talk about the second. But so the due diligence, obviously the buyers have the option of checking is or is not conditioned upon their due diligence, which everybody hopefully is fully aware of that. And then it goes through here in 8.1a and specifies basically what that means, saying that the buyer's due diligence shall consist of the buyer's review and approval of the consent to the seller disclosure referenced in section 7 and any other tests, evaluations, and verifications of the property deemed necessary or appropriate by the buyer. Then it goes through to list, all of the different things that they could, and maybe I shouldn't say all, a lot of things that they could be evaluating and list, square footage, the physical condition, all of that kind of stuff, details about the HOA, any of those kinds of things. But one of the things that I do want to make sure to point out from this section, since we are here, is all of the buyer's due diligence is paid for by the buyer, conducted by individuals and entities of the buyer's choice. The seller agrees to cooperate with the buyer's due diligence, and the buyer agrees to pay for any damage to the property resulting from their inspections. So again, just the buyer's responsible. They get to go check out anything that they want to check out, and the seller is agreeing, yes, we'll allow them to do that. The buyer then is also saying, hey, if I create some damage, I'll be responsible for that damage. Okay. So now they've done their inspections. Then they have in section 8.1b here, the right to either cancel or resolve their objections. So from here, then the buyer can either just cancel the contract, in which they get the earnest money back without any authorizations from the seller, or they can no later than than the due diligence deadline referenced in 24B, resolve in writing with the seller any objections the buyer has. Now, in terms of that, what I have found works the best on that is it's best to just start either verbally or via text or an email of, hey, here's what we're going to be asking for, and negotiating that either verbally via text or an email of what the buyer is going to ask the seller to do. And then once you come to an agreement, then go ahead and throw that into an addendum. And what I'm going to recommend is to use the resolution of due diligence addendum, which you can see down here in just a minute. We will pull it up. But that's where I'm going to recommend that you do the putting that in writing to resolve your due diligence issues. Okay. Then 8.1c, though, does say if the buyer fails to cancel the REPSI or fails to resolve in writing with the seller any objections, the buyer has arising from the due diligence as part of 8.1b, buyer shall have deemed to have waived the due diligence condition and except as provided in 8.2 and 8.3, the earnest money shall become non-refundable. So if they don't do anything and you get past that deadline, in essence, they're saying we're good. It's the due diligence has passed now, and the earnest money has now become non-refundable, except for whatever you've put in 8.2 and 8.3. Now, let me speak on that for 1 second too, because on a totally different transaction this week, talking with an agent, the agent came to me. There's a dispute going on between the buyer and the seller. We're on the seller side, and the buyer's broker called me saying, hey, we are entitled to the earnest money because you failed to provide to us all of the items in the seller disclosures of Section 7. And so I called our listing agent and said, hey, did you supply those things? And they said, yeah, but it doesn't really matter because they've passed their due diligence window. And I think what the agent was referring to is back to this section here of saying, hey, they failed to cancel or resolve objections during their due diligence. And so the agent was saying, therefore, that earnest money is now non-refundable because they failed to do anything about it. When keep in mind, that doesn't change, meaning, yes, they passed the due diligence deadline, but if you as the seller didn't provide them all of the items in Section 7 for the due diligence, or excuse me, seller disclosures, you would now have this is where that first breach rule comes into play, is who is the first party to breach the contract? Well, the seller did because they didn't provide these documents. Now, good news on that one. We got it all worked out and it's proceeding towards closing. And we did an addendum actually to specify that everything is good and the earnest money has gone hard, all that kind of stuff. But just keep that in mind of there is still the first breach rule. So even though this section is saying the earnest money will become non-refundable, well, that's assuming that the seller provided everything in Section 7 for the seller disclosure. So hopefully that makes sense. Okay. So, and feel free to stop me if you have questions as we're going through this, but the resolution of due diligence addendum. So now we've done our inspection. We have the right to either cancel or resolve objections. Typically, you're going to then say, okay, you go back to the seller. You're saying, hey, here's what we want you to fix. These are the items. Doing that either verbally, text, or an email. You come to some type of an agreement of what the seller is going to do to resolve those objections. And which, FYI, the reason we want to do it via verbal, text, or an email to begin with is because sometimes, and in fact, I use this example a lot, is my very first listing that I ever sold. The buyer's agent brought a list to us of items they wanted repaired. There were 72 items, and I kid you not, 72 items that they were saying, we want all of these things fixed. Well, the truth was the agent was using that as a way to negotiate, meaning he sent over to the seller, we want all 72 of these items done. When in actuality, there were only 5 or 6 things they really wanted done. But from the seller standpoint, my seller was like, holy cow, look at this long list. And so then I called the agent to say, hey, what is the deal with all of this? And he was like, we would be workable, but we for sure at least want these 5 things done. So I went back to my seller and said, hey, here's the 5 things that they really want done, even though they asked for the 72. And my seller was kind of like, well, we'll do that, but we're not doing all 72 items. So to some extent, I think it was a negotiation tactic for this agent. And honestly, it seemed to work in that scenario where my client was like, I'll do those 5 things, but I'm not doing all 72. And so they agreed to it. Okay. That would be an example though. But if you put that on an addendum and then the underwriter sees it, you run the risk, the underwriter is going to go, no, I want all 72 of those items fixed. And as we talked about, the seller's already like, I'm not doing all those things. There's no way. So that's why I recommend negotiating it either verbally, text, or in email. Once you come to an agreement, then you're going to use this resolution of due diligence addendum. And what you want to do is you're just going to number this as whatever the next number of addendums it is that you have. You're going to check the box here that it's an addendum to the real estate purchase contract. Obviously, put in the offer reference date, who the buyer is, who the seller is, and the address. Then from here, you're going to check one of these three boxes. And the three different options that you have then from this due diligence is one is to say, okay, we're going to increase the amount of closing costs that are being paid by the seller. And so in this section, it's saying again, seller and buyer agree that the buyer accepts the property as provided in section 10.2 and 3. 10.2 and 3 is basically saying as is. So they're just going to accept the property as is, but that the seller will contribute at settlement an amount of X to be applied towards the buyer's either their financing costs, their closing costs, prepaid and escrows, and any unused portion of that could be used to reduce the price. So that's one option, is to have that done. And then as a reminder on this section here, it does say any amount that you put in here is in addition to, so this, it's not highlighting very well. Anyway, this section here is in addition to any amount that you have already asked for. So in your offer, if you had asked the seller to pay, let's just say $10,000 in closing costs, and then now you're coming back and saying, hey, we want another 5,000, you would write in 5,000 here, not 15. But I see that from time to time where an agent will write in there, okay, we're going to have the seller pay a total of 15,000, and they put 15 in here. If you put 15 in here, and especially if you're on the buy side, that's probably not a big deal, because great, you got more money for your buyer. But if you're on the sell side and this comes in, please take the time to verify that the amount here is in addition to, meaning you're adding it to whatever you've already agreed to. It's not the total. And a lot of times agents will fill it out thinking it's the total. And if you have your seller accept it, they now just agreed to way more in closing costs than they were planning on. So that's one option. Second option is to reduce the purchase price, and you would just put whatever the purchase price is going to be there. And then the third is the repairs to be made by the seller. And then you are going to list them in here, the repairs that you want to have done by the seller. Now, one of the things, again, to point out on this addendum here is that it does say seller shall, through contractors, complete the repairs to comply with applicable law. So keep in mind, again, same thing when you're on the seller side, if the buyer gives this to you using this addendum, they are agreeing to have it done through contractors, not that they're going to do the repairs. So if they are going to do some of those repairs, then you would want to do a counter back to this addendum saying, hey, the seller is going to do X repairs. They'll have a contractor do Y repairs, however that's going to play out. But just keep in mind, they are agreeing to have it done through contractors. Okay. Now, here's the key thing that when I got the call this week from the agent saying, okay, we sent over, and the first question I asked when they said the repairs have not been done, first question I asked the agent was, did you use the resolution of due diligence addendum? They said yes. Now, if they had not, then at that point, it becomes a little iffy of like, okay, what are we going to do? Because there's not a set answer to what's going to happen. But if you use this resolution of due diligence addendum, you'll notice here in 3.1, it has buyer's remedies for unfinished repairs. So think of it this way. What's happening when you use this resolution of due diligence addendum is you are already, between the buyer and the seller, agreeing, hey, you're going to do these repairs, but if you don't, this is what's going to happen. So you have already pre-agreed to the resolution if they don't do the repairs. Now, you may or may not like the idea of this, but this is what it is, okay? So it's saying if, as of the settlement deadline, the repairs have not been completed, then the buyer may enter into an escrow agreement with the seller approved by the lender to finish the repairs after closing. So that's the first thing. Is our first thing is if they are not done, the buyer and the seller, as long as the lender is good with it, have already agreed they're going to enter into an escrow agreement. But it goes on to say, in the event the seller and the buyer cannot agree on the escrow, or it's not approved by the lender, then the buyer may alternatively elect one of the following remedies in 3.1a or 3.1b. If 3.1a or b is not checked, then the escrow is the sole remedy. So if you don't check one of these two boxes, your only remedy is that escrow agreement. And if the buyer and the seller can't agree on it, then I guess you got to figure out what's going to happen. I mean, really, at the end of the day, the seller would be in default for not having done those repairs. So let's take a look at what happens then if you're going to check either 3.1a or 3.1b. And here's the two options. Is one is that so now keep in mind, if we cannot agree on the escrow amount. So the first thing is we're agreeing we're going to escrow. But if for some reason we don't agree on it, then this is what will happen. Okay. Is 3.1a is the buyer will cancel or may cancel the REPSI. And in addition to the return of the earnest money deposit or deposits, except from the seller as liquidated damages, a sum equal to the earnest money deposit or deposits, and seller agrees to pay the liquidated damages upon demand. Or B, the buyer may complete the purchase of the property and then pursue any other remedies available at law after closing, and the terms of this section survive closing. So here's what happened is the agent called me and said, hey, the seller is saying they're not going to do these repairs. They won't agree to doing an escrow. So what's going to happen? And I said, well, did you use the resolution of due diligence? Yes. Which box did you check? Well, we checked A, 3.1a here. I said, okay. And he said, or I should say they, he or she said, he said to me, okay, but so the clients just want to go ahead and do the purchase, and then we'll go ahead and go after them in court to get the money back after. And I said, okay, here's the problem with that. You already agreed that that's not what's going to happen. So your only option, if they're not going to do the repairs, is that the buyer can cancel and get their earnest money back plus an amount equal to that. So unless you can get them to agree to something differently than that, you have already agreed this is what will happen. So part of why I wanted to bring this up is I think it's important for you with your buyer when you do this resolution of due diligence is to talk to them and say, okay, they've agreed they're going to do these repairs. So I'm going to send over this addendum to them to sign that they're going to do the repairs. But in the event that they don't do them, what are you going to want to have happen? Meaning, like, let's talk about with these repairs specifically, if these repairs don't get done, are you going to just want to cancel the contract, or do you want to go ahead with the contract and then, basically take them to small claims court or whatever to get the repairs done? And make sure that your client knows you are all agreeing beforehand, this is what we're going to do. So it's not like later on you can go, oh, we changed our mind. Because unless you get them to agree to signing differently than that, the agreement is they get the earnest money back plus an amount equal to that. If you've checked this box, is you're going to then cancel. So anyway, hopefully that makes sense. The other thing to point out on this, the last thing, and then I'll take any questions if you have them, but is the due diligence condition. So upon the acceptance of the addendum, buyer's objection to the due diligence shall be deemed resolved, and the due diligence condition is waived by the buyer, unless you check here. So once you work this out, if you're good with saying, hey, all of our due diligence is resolved, do not check this box. If you're saying, hey, we want to still keep that door open to walk through if we need to until our due diligence deadline, then you want to check this box that's saying, hey, we've resolved it, but it's not waived. We may want to check something else out. So just keep that in mind. If you do not check this box by submitting and signing this addendum, you're saying, yep, we're good. There's no other issues. We've now waived our due diligence deadline, which there can be an advantage to that too. So let me make sure you understand the advantage to that. The advantage to waiving that is once that's done, typically the lender is going to feel comfortable ordering your appraisal. Until then, they usually are going to wait till your due diligence deadline has passed to order the appraisal, because the last thing they want to do is pay for an appraisal and then the buyer cancels under due diligence. So even if you do keep this open of saying, hey, we're not going to waive it, make sure you're letting your lender know, hey, at this point, we're good. Like, we're going to leave it open, but we're probably not going to do any other tests or inspections. So you can go ahead and order the appraisal. That's kind of the key thing with that. Of sometimes we feel like, well, no, I want to keep it open as long as I can. Just recognize that also could slow down the appraisal getting ordered as well. So, all right. I feel like I talked really fast on that. What questions, thoughts, comments? This is where somebody says, oh, you've been muted the whole time.
No, you did a great job explaining that. So
Yeah, I think I'm good.
Thank you.
Cool.
Yeah, I'm good too.
Russ, I have a question.
Yeah, go
in
ahead,
the
Barry.
beginning, when you were talking about that first breach rule, if we needed to refer to that or read about it, where would that be stated?
So you'd have to you could go to Google and look it up, first breach rule in Utah.
Oh, okay. Okay.
But essentially what it is once somebody breaches, the first person to breach on a contract basically means you can't now hold the other party to the contract because you were the first one to breach. And something that our attorney said to Jason and I that I actually had never thought of before, but it actually makes sense, is the longer a contract is in force, the more likely somebody will breach the contract. So the shorter, the better in your terms of your contracts.
Okay, thank you very much. That's
Yep.
great.
You're welcome. All right. Anyone else going once? Oh, go ahead, Tracy.
Is there a specific place that we can get all the recorded compliance meetings and stuff? Because like I was just driving and then I'm like, oh, I missed 10 minutes. So
Yes. So we put all of them on our YouTube channel. So if you go to Century 21 Everest Training, so go to YouTube, search Century 21 Everest Training, it'll bring up our channel. And then there's a playlist on the channel for the compliance videos. And so they're all there in the compliance videos.
awesome.
Yep. We do that
Thank
for
you.
two reasons. One, for you guys to have access to, and two, so that if the division ever tries to come after my license, I can go back and say, no, I trained on it. Here's my proof.
Yeah, good. All right. Thank you.
Yep. Yeah, you're welcome. Thank you, Tracy. All right. Hey, thanks everyone for taking the time to jump on. Jason and I really appreciate. And, unfortunately, it's the people who didn't get on are the ones that we usually end up having the problems with. So thank you for being the people we don't have problems with.
Thanks, Russ.
Okay, see you guys.
Take care.
Bye.